Good evening and welcome to everybody. I'm very pleased to be here today. And this evening, we are going to start a series of meetings with key experts in international and comparative labor law. I'm very happy to be here today. And first of all, I want to thank Professor Moscella. He's a full professor and he's one of the most active professors, as many of you know. And in particular, I want to thank you, Professor Manfred Weiss. I hope I pronounced it in the correct way.
Weiss means bianco.
Yeah.
Sure.
Weiss, and he's professor at Frankfurt University. And thanks to Elena Sischenko, and he's a professor at St. Petersburg State University. My name is Antonella Ferri. Most of you know me. I'm the Dean of the Economic and Law Faculty, but I'm also the coordinator of one of our PhD courses. Universitas Mercatorum has established 3 PhD starting from 1922, and the PhD that I coordinate is based on financial management and corporate crisis. The other PhD are focused on big data and artificial intelligence and on sustainability and ESG agenda. I want to say just a few words to introduce the lesson that Professor Weiss will give us this evening. Our courses, our PhD courses, as the main objective to promoting and encouraging the research in different areas, in the area related to our PhD courses. In particular, the PhD course that I coordinate, the course is based on financial management corporate crisis, is organized in 3 years. The first year, our aim is to give the fundamental knowledge in business, in economic law, but also in ethical and social aspects. And in the second year, the training, the activity training, shift on more specialized subject. And in this context, we asked to Professor Weiss to come here. So I thank you again for your participation. And I don't know the subject that Professor Weiss will give us today. I'm sorry, I can't stay for all the afternoon, but I'll follow online. And now I'll give the floor to Professor Moscella. Thank you.
Professional activities of the Mercatorum University continues to thank impulse given by Professor Shishchenko with the creation of a hub for international and comparative labor studies. The activities of the hub are diversified to meet the needs of all. First, the Mercatorum talks, seminars by great international name, open to the public and PhD students. We started with Professor Jean-Michel Servet, former director of ILO and current president-elect of the ESLLSS. Continue today with Professor Manfred Weiss. In this way, we intend to create a large collection of contribution of the service of researchers from Italia and foreign. Other activity of the hub is the hosting of young foreign researchers and PhD students hosted at the Officina Mercatorum, with access at our virtual library and all activities of the university. Finally, we are pleased to announce the launch of a call for visiting international researchers. Foreign researchers who would like to carry out a period of study at our university with a fellowship for at least 1 month. We are planning a call for around 20 scholarships that will be issued early next year and to which we will do extensive publicity. But today, we have the pleasure and allow me the honor to have the Professor Marco De Weiss as our guest speaker. He's a emeritus professor at Frankfurt University, visiting professor at numerous universities worldwide. He was a consultant of international labor organizations since 1980, participating in mission in 20 countries. Manfred Weiss has been a pioneer in comparative labor law and a role model for labor law scholars like me. In this work, he carried on a new approach to legal research, in open defense of the weakest, and through the principle of the no one behind, which today characterizes the work of the European Union and United Nations. I don't think there is a professor in labor law in the world, and particularly in Europe, who's never read anything by Professor Weiss. And I think. And for this reason, it's a real honor for me to have him here today. Thank you very much.
Well, thank you both for this nice introduction. Good evening, everybody. And I would like to thank first to the organizers for having invited me. I had the pleasure formally to very often be in Rome, but never so far at this university. So for me, it's something new to be here. And I can say for what I have seen so far, it's a great pleasure to be here. If I see these rooms, you know, I'm thrilled. Okay, what I'm going to do tonight is the following. Professor Sishenko asked me to first say a few words on comparative labor law. And then I'll go into transnational law to the European Union, talking a little bit about the ups and downs of European labor law. Let me start by my few remarks on comparative labor law. First, let's ask, why do we need comparative labor law? And there are, in my view, at least 3 reasons. The first reason is evident. We are living in the era of globalization. We have international commerce, international trade. I don't have to explain at this university. And since we have this, well, we badly need to know other systems in order to save transaction costs. That's the first reason, and this is evident. The second reason is also very important. Whenever we think of transforming or reforming our system, well, it's good to look for experiences elsewhere and to look for ideas elsewhere, not looking for the arrangements they have there, because you never can transform an arrangement from one country to another one, because the cultural, political, historical, economic, and so on conditions are totally different. But you can transfer ideas and experiences, and this is helpful. And then there's a third reason, which in my view is the most important. And this is to better understand your own system. What do I mean by this? When you compare with other systems and you find out they have a different answer to the problem we also have in our country. Then you start thinking, why did they do it differently? And then you look for the reasons. And you look also for the reasons in your own country. And you start to understand, why did we do it in Italy this way? And why do they in France or in England or I don't know where different? That's how you understand your own system. I can tell you from my own lifelong experience, I have learned German labor law. Not when I studied labor law, this was superficial, when I was abroad and when I started to think, why the hell do we do it differently in Germany? Then I looked behind the scenes and then I started to understand it. That's, in my view, the most important you can get from comparative labor law. And then the question, of course, we have to ask, how are we doing it? How is comparative labor law to be done? And there is first a negative answer. The first negative answer is it's totally useless to only compare law, rules, institutions, instruments. Because, you can resolve the same question with different instruments. For example, when you want to protect against unfair dismissal, well, you can make rules on dismissal law. But you also can make rules on fixed-term contracts, or you can make rules on temporary contracts and so on. And, well, the result can be the same. So it would be useless to only compare the same institution or the same rules. This doesn't help at all. And secondly, and that's most important, well, even the same instruments, when they are used in different countries, this does not mean that they have the same practical and actual effects. Why? Because, as I already said, each system is different politically, culturally, economically, and it has a different history, a different tradition. So if you keep this in mind, then you understand that the effect of a specific instrument can be in country A totally different from country B. So what we are interested in are not the instruments. What we are interested in are the legal effects, the function. And that's what we call function. That's what we call comparison nowadays, functional comparison. The great thinker of the last century, Otto Freund, a German Jew who had to emigrate under the Nazis to England. He developed this kind of thinking. And since it's taken for granted that comparison only makes sense if it's not only on the normative level, but if it is looking into actual practice, if it's functional comparison. This, however, is difficult because, legal knowledge is not enough to understand this. You have to cooperate with social sciences who look into reality. You have to look into empirical studies of sociology. You have to cooperate with economists. You have to cooperate with historians, and so on, so on. We call this interdisciplinary approach. This does not mean you have to be at the same time a lawyer and the economist and the sociologist and the psychologist. I don't know what. This, of course, would not be possible. It's evident. But you have to learn to communicate with these kind of sciences. to understand what is the result of their research, and you have to integrate these results in your research. This is very, very difficult. And it's getting even more difficult, because if you take it for granted that the reality is very complex, the reality is the result of, as I said already, political, economic, cultural, and so on tradition, then of course it's not enough to study one element of labor law of another country. For example, if you would study, let's say, collective bargaining in Italy and collective bargaining in Spain, well, you might find all kinds of differences and similarities. But the question is, what is the result of collective bargaining in both countries? And this you only can understand if you not only look to collective bargaining, but if you look to the surrounding framework, to the whole actually scenery of reality. And this is getting more and more difficult. And then, of course, you have another problem. And this is a problem of language. A good comparatist, if he does comparison, has to know, or at least to understand, the language of the country where he or she is comparing. And then there is a further problem. If you look at the notions, for example, let's take again collective bargaining. If you look to collective bargaining, in one country, collective bargaining means something normative, legally binding. In other countries, like, for example, in the UK, it's a sort of gentleman agreement, you can use or you can leave it, The question of the scope of application of collective bargaining is totally different in each country, and so on and so on. In other words, if you talk about collective bargaining, it doesn't mean the same in each country. It means something totally different. If you take all this together, you will agree with me that it is almost impossible for a single person to do these comparisons. Therefore, I highly recommend to build international teams. And in the way of cooperation between different teams to do comparative work. You have an Italian team, you have a Spanish team, you have a French team, and they look into France, into Spain, and you look into Italy, then you discuss it. That's comparison as I understand it, and that's how we have to do it. And I told you why we have to do it. Now I stop with these preliminary remarks and I go into Europe. And when I go into Europe, I'm no longer on comparative level, I'm on transnational level. And before, and now of course I'm boring, before I go into labor law, I have to make some preliminary remarks on Europe to get understood. Otherwise, we talk about things which you may not understand, and this is not my intention tonight. Well, if you talk about the European Union, we have to go back into history, and we have to start from the scratch to understand where we are. As you know, in 1957, the European Economic Community, as it was called in that time, was created here in Rome, the Roman treaties. And why do we have only economic community, European Economic Community? This was the result of a big fight. Before there were two groups. There was the so-called federalists. The federalists were those who would say, what we need is a federal state of Europe. And then there were the so-called functionalists. They would say you're crazy. It's much too early. Maybe someday we might have a federal state of Europe. Let's start with a segment of society with a function, and let's take the economic function. And let's just make a common market and nothing else. And this was the idea in the beginning. That's important to know. The second, I'll show you later why it's important. The second which is important to know is the following. And that's basic. In the beginning, we were 6 countries. Italy, France, Germany, and the Benelux countries. And if you look at these 6 countries, they were relatively, and still are, relatively homogeneous, politically, economically, socially, and so on. How does it look nowadays? Now we have 27 states. And if you look at these states, I can't go into this, they are very heterogeneous, socially heterogeneous, economically heterogeneous, politically heterogeneous, which means it's much more difficult to handle this. Very important message. And I tell you, this is not the end. We will be many more. In a few years, we will have to integrate the Balkan states. You know the Balkan states. I don't have to list them up. We will have to integrate the Ukraine, and then we will be many, many more, and even more heterogeneous as we already are. And this will increase the problems. Then, of course, we have to see that the European Union, and this also applies from the very beginning to the European Economic Community, is unique in the world. Why is it unique? Because it's a supranational entity. What does this mean? It means that the member states are giving away sovereignty to this body, the supranational entity, Europe, and the European Union has legislative, judicial, and executive powers, which is very, very important. But as far as legislation is concerned, the member states are very cautious. The member states from the very beginning made sure that the European Union only has powers to legislate if it's expressly stated in the treaty. To be sure that you can control that not too much sovereignty is given away to the European Union. And this is still a big fight until today. There is one exception, a specific article, which is still in the treaty nowadays. You know, we had many amendments. And nowadays it's article, for those who like numbers, 352. And this article, well, is a sort of, how do you say, excess, you know, which means if a certain goal, which is in the treaty, cannot evidently be reached by the powers on legislation you have in the treaty, then it's possible to nevertheless legislate, but only, and nowadays this is absolutely impossible, unanimously, which means all agree. And then, of course, you have to know that European law always has priority in comparison to national law. This, by the way, is strongly attacked in the moment by Hungary, and it was attacked by Poland. Now the new government certainly will not continue this, but in Hungary still there is the idea that, well, we have to get rid of this priority of European law, which in my view would be the end of everything we have achieved so far. Well, what are the instruments for the legislator? Then I stop with my preliminary remarks. The instruments, we have two. The one is the so-called regulation. And the regulation means that, well, the legislator, the European legislator, creates a legal act which applies automatically the same way in all member states. This does not play a role in labor for a very simple reason, because the conditions in each country are so different that the practical effect, if you have the same law, would be different in each country. Therefore, we have another instrument which is much more flexible, and that's the so-called directive. What's the difference? In the directive, you only put in the goal you want to achieve, and some basic elements, and then you leave it to the national legislature, which is transposing the directive into national law and adapting it to the overall framework already existing in the respective country, in order to make sure that the practical effect everywhere is the same. This is important for us, the directive. And well, I forgot to say something which I also have to say. So I was a liar when I said this is my last remark. Well, that comes with age, you forget. We have to see the bodies who do this. There is one body which we call the Commission. You have certainly heard about it. The Commission is, if the European Union would be a state, we would say this is the government. It is an executive body, I would say. And this executive body, that's why I tell it to you, has the exclusive power to initiate law. Only they can do it and nobody else, the Commission. And then we have another body, and this is a very important body. This is a Council of Ministers, which means from each government, you have one representative in this body. Now it's 27. And they are legislating. They are deciding on the proposals of the Commission. Formally, they did it alone. Since 1979, they do it together with the Parliament. That's all I tell you about these bodies for the moment. Now let's go into labor law, finally. Well, let's go back again to 1957. How did it look like in the original European Economic Community? If you look at the treaty, you will be very disappointed, even if it's made in Rome. Well, what did they put in? What they needed. And what do you need to have a common market? You need, first of all, the so-called market freedoms. Free movement of capital, free movement of goods and services, free possibility to have a business wherever you like, and free movement of workers, because you want to optimize all factors you need for a functioning common market. These are the market freedoms. They were in the treaty. And something else, which you need to make sure that the market is fair. And in order to make the market fair, you need antitrust law. And therefore, from the very beginning, we had market freedoms and antitrust law, making sure that there are not kind of agreements between the powerful companies, to abuse their power in order to destroy free competition. What about labor law? Well, this is a disaster. If you look to the preamble of the treaty, you find there should be social progress. The question is, where does social progress come from? There was a very naive idea. It will come by itself automatically once we have a functioning common market. Consequence, no power for the EU in labor law. We leave it to the member states. Only two exceptions, if you want, not real exceptions. The first one I already mentioned, freedom of movement of workers, including the right not to be discriminated in relationship to the local workers. Well, this was done not for social reasons. This was done, as I already explained, for economic reasons, in order to have an optimal allocation of the labor of the workforce. And then there is a second thing, which looks like labor law. Equal pay for men and women for equal work and work of equal value. Again, it has absolutely nothing to do with labor law, and it has nothing to do with women emancipation. No, it has to do with the following, that some of the countries, of the 6 which I told you, they already treated their women relatively well, more or less equal. France and the Benelux countries. But there were 2 countries which behaved badly. This was Germany and Italy. And in order to make sure that there is a fair and equal competition economically, well, they said, in particular the French said, you also have to treat your women no longer as slaves, but as real human beings. So we were forced to do it. This was the idea. It has nothing to do with labor law. In other words, to make the point, in the beginning, it was clear labor law is not a matter for the European economic community. Well, how did it come that labor law started to somehow grow and somehow be a matter of European law? Well, in the 70s, we had, you might remember from reading about it, well, we had the first oil shock in that time. We had enormous unemployment in Europe. The conditions became worse and worse. And the idea, of the founding fathers and mothers of the European project, that things would be better automatically once the common market starts to function, well, it turned out to be naive. So in 1972, the heads of state of these 6 countries got together in Paris. And they found out, well, the situation is catastrophic. We have to do something. And they made a resolution to ask the Commission to start an action plan on social policy. which the Commission did until 1974. It was a huge paper with many, many directives to be made. How to be made? Nothing in the treaty, but I told you already, there is the annex article, and you can put it on the annex article once you have unanimous decision making, and they all agree. So it was no problem. So without having any legislative power in the expressive power in the treaty, we got directives, for example, on equal treatment of men and women, not only equal pay, equal treatment in any respect. We got a directive on protection of workers in case of redundancy, or you may say collective dismissals, however you like it. We got a directive on protection of workers in case of transfer of undertakings, and so on. And there were lots still on the agenda. But here you can see one thing, if there is agreement between all the member states, the treaty becomes irrelevant. Then unanimously they can do what they like. But in spite, we had still an enormous program. This stopped in 1979. Why in 1979? Well, because in that year, Maggie Thatcher came into the scene. Since 1973, the United Kingdom was a member state. And Maggie said, not with me. And this was the end. And I can tell you, at that time, I was in the midst of everything. And my friends and myself, we thought, that's the end of social policy in Europe. And we were very, very sad, totally hopeless. But as it happens, as a sort of miracle, we got a new president of the Commission, a man whose work cannot be overestimated. The name is Jacques Delors. Jacques Delors, a French. And he, from the first day, he developed the formula, la dimension sociale de l'Europe, the social dimension of Europe. And he did everything to restore the social dimension of Europe. He was the guy, who also woke up the trade unions in Europe who slept until that time, as far as Europe was concerned, unfortunately. But what he really did was to campaign for amendments in which you can put powers to legislate on social policy. And the first one of this was in 1986. This was the so-called Single European Act, where he opened a little bit the door of legislation in the area of labor and social security. This was not enough. He went on and on. And then we got, effective from 1992, the amendment of Maastricht. We always name the treaty and the amendments according to the city where they are signed. Maastricht is a beautiful town in the Netherlands. Now, Maastricht became very important. Why? Because the idea was to have really a big chapter on social policy with lots of powers to legislate in the area of labor law. The Commission informally presented the social partners, all kinds of proposals, and social partners said, rubbish. Either the employers or the trade unions They didn't like it. So the Commission, they did something which was problematic. They said, well, do it yourself. So they would sit together, the social partners, and draft a so-called social protocol. And this social protocol, in the last minute, actually, was taken by the Commission, not changed anymore, and just given to the negotiations on the amendment, and it was put as a part of the treaty, but not in the treaty, a separate document, which, by the way, ended up with the opt-out of the ongoing troublemakers, namely the UK. And it was adopted by the others. Now, what is new in this social protocol? Just to give you an idea. First of all, we have now, and this was later on taken in 1998, the so-called Amsterdam Treaty. It was taken into the text of the treaty, and then the UK had a different government, the Blair government, and they ended the opt-out. Well, what's new? That's now the situation we still have. First of all, we have now a comprehensive power to legislate in labor law, except, and this shows you why it's a work by the social partners, pay, freedom of association, the right to strike, and the right to lock out. The social partners didn't want the European Union to interfere in these areas. And that's until today. We don't have a power to legislate in these areas. That's why, by the way, the European Union cannot legislate on collective bargaining, nothing. No. The trade unions nowadays regret very much to have done this, but in that time they did it, Well, this is the first thing, comprehensive powers. Second thing, you do not need anymore unanimous voting. You only need qualitative majority. I cannot explain now, it would take too long what this means. Just as a short version, it means more than simple majority. You have to have a certain amount of states and of population to fill this requirement. Yes? That's majority vote. Then we had a problem to be resolved. If you have comprehensive power to legislate in labor law, well, the member states start to ask, and what about us? Now you have to regulate how is the relationship of powers of the European Union and powers of the member states. There were many proposals how to do it. In the very end, we just took two principles which until today are regulating this relationship. The first is subsidiarity. What does this mean? It means as long as something can be regulated by coordinated action of the member states, it's none of the business of the European Union. Only if that is not possible, then the European Union can legislate. It's a very vague principle, but so far it has worked, and it was further defined and specified in a protocol of the Lisbon Treaty, another amendment of 2004. And the second principle is proportionality, meaning that if the European Union is legislating, it only should do it so far that there is still enough room for the member states. Again, very vague principle, but so far it works. We have not a single case where the European Court of Justice, when it was asked, has said, well, this is no good. You didn't really observe these principles. What is the practical effect? The practical effect is that the Commission, each time when it makes a proposal, well, it has to explain that they would observe the principle of subsidiarity and proportionality. That's all. It's just a sort of mechanism, well, to make the European Union cautious, because otherwise they run in trouble with the member states. Then there is something which I don't go into because it would take too long. Since the social partners made the social protocol, they did something clever from their perspective. They integrated themselves into the procedure of legislation, which doesn't play a role anymore for a very simple reason, because the trade unions have discovered that they have no power to pressure the other side, because European strike is illusionary from a legal and practical point of view. And so it's something which is irrelevant. Therefore, I don't go into it. Then there is something which is important. Only minimum conditions can be legislated. What does this mean? It does not mean very low conditions. It means conditions in relationship to which the member states can do better in favor of the workers. That's possible. And that's all what we find in the social protocol. And this shows you that we have now a radical change compared to the beginning. Now European legislation really can start. Before we have a short look on the European legislation, let me include something else, which also is very important. You know, from the very beginning, we had a big problem. As I told you in the beginning, we had only these market freedoms and antitrust competition law. But then we had European law, and the European law was controlled by the national courts, in particular by the National Constitutional Court, as for example, the Corte Costituzionale in Italy or the Bundesverfassungsgericht in Germany, and so on and so on. And these constitutional courts would say, we are not accepting your directives, your law. We examine it according to the fundamental rights we have in our constitutions. We do it as long as you don't have fundamental rights in your treaty. And then you got a big discussion starting in the 60s that we would need a charter on fundamental rights. It took until the year 2000 until we got it as a ceremonial declaration in the summit of Nice, and we finally got it as binding law in the treaty in 2004 with the Lisbon Treaty. Why did it take so long? It took so long because the real question was, should we include fundamental social rights or not? And there was a big group who would say, never, don't do this, because social rights are not real rights, and they are not fundamental. They are simply goals, and they would undermine the authority of a charter of fundamental. Others would say, what we badly need are fundamental social rights, because then only we give a signal that the social is on the same footing as the economic. It was a big battle. In the very end, those who were for fundamental social rights won the battle. Last not least, because they remembered the wonderful writing by Anatole France, the French writer. He once wrote, "The rich and the poor, they have the same right to sleep under the bridges of Paris. But the rich don't have to do it. They have better choice. Only the poor have to do it." Which shows you that if you don't have the social basis, all the other fundamental rights are not really helpful. And since people finally understood this, we have now a wonderful chapter in the Charter of Fundamental Rights, which you should read, titled Solidarity, and there you have individual and collective rights. Fantastic. Well, having said this, it should be clear for you that now we are on a level where European legislation is easy. And we have quite a bit of European legislation. In individual law, for example, in the area of health and safety, we have so many directives. Most of them I don't understand because they are very technical, and I'm a technological idiot, Well, then we have on atypical work, we have legislation on working time, very controversial and very important nowadays, and so on. But the most important we have in individual labor law is the prohibition of discrimination for all kinds of reasons, for race, for ethnic origin, for sexual orientation, for age, for disability, for religion and ideological orientation, and so on. In other words, we have quite a few directives in individual labor law. And we also have quite a few directives even in collective labor law. We don't, of course, have nothing on collective bargaining because there is no power to legislate. But we have quite a bit on workers' participation. There's a directive on minimum conditions in the member states, and there are directives for companies who operate transnational. And to make sure that if you have only in one country where they operate workers' participation, but not in the other countries, well, you have now a mechanism, the so-called European Works Council, which is on the level of the headquarters for decisions, transnational decisions, which are made on the level of the headquarters. Very important practice. And then we even have now directives, several directives on European company and so on workers' participation or representation in the boards of the company. So we have quite a bit in this area, which is made relatively flexible, giving the individual states lots of flexibility because there is no possibility to have a uniform structure in Europe and to harmonize. These all are notions which are nonsensical. You only can bring things closer together and have to leave flexibility. And here we have this, and this will go on and on. So we could be happy, and I could stop here, but I don't. Because if you look at this, you will find out it's unsystematic and it's very fractured. Lots of things are missing. Just to give you one example, we have no directive on protection against unfair dismissal. And you will tell me as an Italian that unfair dismissal is a topic which has some value, you had some fights on this. as far as I know. Okay. How did it go on? Well, we had now the door open for labor law legislation. But we didn't get it. Why didn't we get it? Because, and these are now the downs, because we have, as I said in the beginning, so many member states with heterogeneous interests. You know, we have low-wage countries. They have a totally different interest in the high-wage countries, you know. So it's very difficult to get a qualified majority for any sort of directive. And this led to what I would call stagnation. And then the European Union, it was called European Community since the Maastricht Treaty, 2002, and it was called European Union since 2004, the Lisbon Treaty, you know, growing more and more into from the mere economic community to a political community, and perhaps one day to a federal state, we don't know. Well, let's come back to the stagnation. The European Union discovered something else, what I would call soft law or light touch law. First of all, they developed a certain method. They did this already in 1998 in the Amsterdam Treaty, when they developed the so-called European employment policy. This part is called open method of coordination. What does it mean? It means the European Union doesn't do anything. The member states look one state to the other, and they look for best practices. And then they try to imitate the best practices in their own country. And thereby progress again will come up. Well, this of course is voluntary. There's nothing legally binding. And secondly, you know, this kind of, the idea of best practices doesn't work if you have a gap between high wage and low wage countries, you know. It works if you have countries of, let's say, a similar level, but it doesn't work when the level is totally different. So, well, they found out that this method alone doesn't work. Now in 2000, they invented something which got a name. They called it Lisbon strategy. What is the secret of the Lisbon strategy? You take this method of open coordination, or the open method of coordination, and link it to specific goals. For example, you say, what we have to achieve is, they created a word, catchword in that time, flexicurity, meaning you at the same time you do flexibility and security. But of course, nobody knew what does it really mean. How much flexibility, where flexibility, what kind of flexibility, and what kind of security, nobody knew. It was a vague thing. As a sort of goal to be achieved. Or employability, you know, to do everything to make sure that people can be employed, you know, things like that. And then the Lisbon strategy, you know, was very ambitious. In 2010, we should achieve a situation where we are the most prosperous economy in the world and having more or less full employment and so on. Well, as you know, nothing of this happened. It ended up with big problems For example, from flex security, well, there was not much security anymore. It led to a sort of deregulation, flexibility, and it was not what was expected. It was not improving the social scenery. It was just doing the contrary. Then in 2010, we said, but now we start with something better. We called it Europe 2020. And now in 2020, we want to be such a wonderful community. What did we change? Almost nothing compared to the Lisbon Treaty, only we made 5 different goals and defined the goals more specifically than it was done in the Lisbon Treaty. But as we all know, now we have 2023, nothing happened. Only it became worse. Why was this the case? And here is a secret which you have to know. Lisbon Treaty and Europe 2020 were under the roof of macroeconomic governance. And macroeconomic governance had many instruments, which I can't go into, don't have time. There are very many, some still exist. And this macroeconomic governance had mainly the goal economic efficiency via mainly monetary policy, which meant for the Lisbon Treaty and for the Europe 2020 that legislation in labor law only could be made if it doesn't interfere in the goal of economic efficiency. So we were under the roof of economic efficiency, and we were a sort of residual category labor law. This, of course, led to what I would call the economic deficit of the European Union. The European Union more and more was looked upon as an entity for big business, but not an entity for the working people, for the poor people, and so on. This was ignored. Nobody would care, except some stupid academics like myself. But we, of course, were not heard. And then came something which had nothing to do with social policy. The Brexit. The discussion on the Brexit was very helpful. The Brexit came, of course, because of other things, because of migration policy. But the Brexit was a sort of wake-up call. Now people started to think again about the legitimate basis of the European project. And this led to something which, in my view, cannot be overestimated. We had a president of the Commission, Mr. Juncker, man from Netherlands. And he was far-sighted, and he saw that if we are not improving the legitimacy basis of the European Union, and we only can improve it by improving the social policy dimension. Otherwise, we lose legitimacy. He had a marvelous speech in 2016. No, this was the year when we got the referendum in the UK, you remember. And he created what he called the European social pillar, European social pillar of rights, or pillar of social rights. I always abbreviate it. European pillar of social rights. This was also a wake-up call for the European Union. And this European pillar of social rights was discussed with the social partners and with all the shareholders in Europe by the Commission. A final version was made, 3 chapters, and finally it became a ceremonial declaration at the summit of Göteborg in Sweden in 2017. And it's not legally binding. It's a sort of, how should I say, recommendation for the EU and for the member states. 20 principles, which partly you have already in the Charter of Fundamental Rights, others, very comprehensive. Another question, of course, what's new? New is the following. You have for the first time an autonomous, and I stress autonomous, and comprehensive program for social policy for the EU. No longer a mere residual category under the roof of European governance led by the goal of economic efficiency, which makes a hell of a difference. It's a totally different perspective. In the meantime, you know, the Commission was asked to take this as a basis and develop an agenda, the so-called action plan, which they brought last year. And now if you read this action plan, well, you have a marvelous agenda for the future in social policy. Of course, you may say, well, that's nice. You can have all kinds of agendas. Does it really make a difference? And this is now the, how do you say, the miracle. We see now a sort of what I would call revitalization of social policy, and then, of course, also by labor. Because the member states have understood that if they do not cooperate and if they do not improve the social dimension of Europe, Europe will not survive. Which means that in spite all the fights they have, you know, they have so many fights. They have a fight on whether they should support the Ukraine. They have a fight what they should do with the migration policy. They have a fight how they should react to Hungary and Poland when they destroy the rule of law, and so on and so on. Lots of fights. You may say, well, this never works. But there's one area where you can see that the European Union now makes a change to the time before. I will give you some examples how this looks like. First of all, we have before, you remember, stagnation, no directness. Now we have quite a few directives. You know, since 2019 until today, it's amazing. I just give you an idea by giving you the titles. I'm not saying too much of the content, otherwise we sit here until midnight. You know, there is a directive on transparent and predictable working conditions. We had already before, long ago, a directive on transparency, which meant that the employer, after a few weeks, has to give the worker a written statement where the main conditions of his or her employment are included. Now, of course, this is extended and no longer only the question of writing down something, but containing lots of minimum conditions. For example, the probation time only have to last so long, and so on, things like that. And this, of course, is an enormous achievement. Secondly, we have a directive on work-life balance for parents and carers. This is very important because before we had already a directive on parental leave. But now we have also a directive not only for parents, but also for carers, people who treat old people like myself, in the family and need some leave from the job, Very important. There you can see what we are missing. What will you be most interested when you are in parental leave or when you are in carer's leave? At least I would be interested. I would be interested in what do I get, how much money. But what did I tell you? No legal competence to legislate in the area of pay. So it's ridiculous. The most important questions cannot be regulated, which means we have to change the treaty, But to amend the treaty means unanimously, and you will not find the unanimously will to change the treaty, which is a catastrophe. Yeah, well, but nevertheless, we have at least the attempt to have the carers leave. Then we have the very famous whistleblower directive, protecting the persons who report breaches of trade union law. This, of course, is very important because until nowadays, in almost all countries, I think also in Italy, if somebody discovers that there is some sort of corruption or I don't know what, and the law is broken, and they report it, well, it will be bad for them, there will be repression, they might be dismissed or I don't know what, or they might be mobbed or I don't know what, in order to make sure that they have nothing to fear, we have now this directive, which is very important. And then we have a directive which is not sure whether it remains. I told you, we have no competence on pay, and we have no competence on freedom of association. But now we have a directive on minimum wage. And in this directive, when you read it, there they talk about the minimum wage, be it statutory or be it by collective agreement, and they talk about a certain structure of collective bargaining. And, well, in particular, Scandinavian countries think that this is not possible because there is no power to legislate. That's why Denmark went to the Court of Justice in Luxembourg. And the case still is pending. We don't know what will be the outcome, but it may well be that this directive might be considered to be null and void. I don't know. We'll see. there are, as you can imagine, lots of forecasts, you know, how it will look like, but nobody knows. Even if the directive remains, and I think it will remain in the very end, it's a very weak directive, you know, more or less a sort of recommendations and nothing else. But at least, you know, it's an attempt to make sure that there should be a sort of basis of wage in each country. Then we have another directive, which is very important internationally. You know, we have these companies, and these companies always had a law for a long time, these corporations, that they have to report financially what they did. You know, they have how the budget is and things like that. You know this. And now, since quite a while, we have a law in Germany, and there's also a directive from the early 2010 on reporting non-financial topics. What have you done socially? What have you done environmentally? And this now in this new directive is extended. First of all, as far as the topics are concerned, and secondly, to the size of the companies, you know. Formerly, it was only the very big companies. Now it's also the medium-sized companies. You know. All these directives, which I just told you, are already existing now. And they were made in the short period after the European Pillar on Social Rights. So you see, we have an enormous revitalization. And this is not the end. Now we get proposals which are fascinating as topic. They may be not fascinating the way they are done. And I only take two of them to give you an idea. There is a proposal of 2021, which is still a proposal, still very controversial, on platform work. Platform work. You know better what platform work is because you are of the digital generation. You are native digitalists. I'm BBC, born before computers. I'm old school. Well, then we have a second one. And the second one is perhaps the most important. The proposal on corporate sustainability due diligence. This is a proposal of the 23rd of February of 2023. Sorry, I was wrong. 2022. One day before Putin started the war. And this was the reason why for a long time nobody discussed this proposal, because we had other things. You know, we had Ukraine and Russia. Now, of course, we have a very controversial discussion. Let me say a few words to these directives. Let's first take the platform directive. One big problem, you know, in platform digital work is the question, who falls in the scope of application of labor law? Or put it differently, who is in an employment relationship? And there are many attempts, you know, you remember the Uber cases and so on, all over the world. Now we get a directive which works with a so-called rebuttable presumption, which means if a certain number of criteria are met, then there's a presumption this is an employment relationship and you are protected by labor. This is very controversial because many people would say it's not enough to simply extend the employment relationship, to extend the scope of application for the employment relationship. We have either to develop new categories for protection, or much better, forget about the whole categories we have so far, looking to the problem from the protective umbrella, asking who needs what kind of protection, and reformulate everything. This is very controversial. Some people also would say, why only a presumption in platform work and not for other kind of work? You know, there are so many new forms of jobs where you don't know exactly, is it an employee or is it self-employed, you know? So it should be broader. Then in this platform directive, we have something which of course is of utmost importance, of which I do not understand anything, I can tell you. This is how to cope with algorithmic management, how to cope with artificial intelligence. And here, well, there are two problems which the directive is focusing, which are important, I agree. Workers' participation, because, you know, there's a big problem of acceptability of these new things. So it's clear it only can be done in cooperation with employees and their representatives. But the big problem, of course, is not discussed. What does workers' participation mean in this context? Because neither the employer nor the employee representatives understand what's going on. And I'm doubting whether it can be explained to them. Though we have to deliver everything to experts. And then, of course, the question is, who is paying for these kind of experts, you know? And is it still workers' participation or is it expert participation? What is it, you know? It's not resolved in this directive. Then, transparency. There, the same question arises, you know. How do you create transparency if nobody understands what's going on? You have to be an expert to understand what's going on. And therefore, I'm doubting whether these attempts in the directive on transparency will be sufficient. To make a long story short, this is still very controversial. We have not yet a directive. The parliament has a totally different view than the people in the Council of Ministers. You know, the Council of Ministers is much more restrictive. The people in the parliament are much more open, you know, so we'll see where it ends up. You know? It cannot be predicted, but I would say they know they have to do something, so it will come certainly in the course of next year. Now let's go to the other directive, which is, well, that's my favorite, you know. As we know, we have, the more we have transnational activities of corporations of all kinds of business, bigger and small and medium-sized, the more we have, however we want to call it, some people call it supply chains, other people call it value chains, you know. Whatever you prefer, the problem is the same. The problem is that we have discovered, and if I say we have discovered, it's mainly NGOs who have discovered, how much people are abused, in particular in the global south, in developing countries, you know, You remember Rana Plaza in Bangladesh, you know, when so many women were killed by a building which was not as nice as this one, but which fell down, you know, and things like that. The idea of this directive is to have a law which obliges the companies to, by way of due diligence, to make sure that no such things can happen, that there are supervisory agencies looking that these due diligence things are really kept, and that there are sanctions, and last not least, to have a possibility for the victims of violations to go to court, not only in their state, which is not helpful quite often, but in the state where the seat of the corporation is, and have no procedural problems, you know, to go through. The last point is the most difficult. As you can imagine, well, first of all, let me say I'm very fond of this plan, of this proposal. Why? We have already such laws, not sufficient, these laws, but we have laws in France, Germany, and some other countries. But this is problematic. If you have such a law, it might be for the corporation a competitive disadvantage compared to a corporation where there is no such law. Therefore, it's of course better you would have it internationally, globally, but globally we have attempts in the Council of Human Rights of the United Nations, but so far the attempts all failed. To have it at least in Europe would be good. Now, how does it look like? As you can imagine, there is enormous resistance against this proposal, because the business world is saying this is, first of all, bringing too much bureaucracy. Bureaucracy is expensive. And it asks of us, since we have to look into countries all over the world, what's going on there, something which we cannot do. It's just too much. Of course, the other side would say, well, it's necessary that this is done because there is abuse. Human rights have to be respected. We have to make sure that people get proper wages, people have a decent working time, people have health and safety structures, and so on and so on. And we have to make sure that those who are victims of violations can go to court and have no problems when they go to court and things like that. So, as you can imagine, enormous controversies. It cannot be predicted how it will look like in the very end. I'm pretty sure it might be at least softened somehow to find a sort of compromise in between the two positions, you know. We will see. But without going further into details, let me say this. If you have listened to what I said tonight, you will agree that it was a long way for labor law to become a real topic on the European level. And there were waves. And thanks to the law, we got an era which was very promising. The heterogeneous structure of the European Union made it difficult to legislate in spite of the fact that the conditions now are much better than ever. Of course, the conditions are not sufficient enough because we still have the exclusion of pay, freedom of association, strike, and lockout. This shouldn't be done, because there again we need the European Union, in particular of pay and the freedom of association, to have also collective bargaining and the possibility to regulate that. Well, but nevertheless, and this is my main message, we see that after the social deficit of the European Union, the actors have understood we have to do something on social level. And there, as I said, Brexit was a wake-up call. And now we do quite a bit. And it's amazing how, and I stress this, in the social area, and only in the social area, the member states are cooperating. So the requirement of qualified majority is no longer a real obstacle. As we have seen from the new directives we have already got and from these fascinating proposals. The question now, of course, is, can we be optimistic? I would say to a certain extent, yes, because I'm rather optimistic on the awareness of the actors that not again social policy can be neglected. So we can expect something there. But again, you know, it would be helpful if we would have an amendment of the treaty with, which I already told you, the exclusion of these topics which we can't legislate. But even more, I think it would be good to have no longer any area, and there are still some areas, as for example, protection against dismissal, where we need unanimous decision making. This shouldn't exist anymore. We should only have majority vote, and I would say the level should be lowered compared to now. And then, of course, we would need more efficiency in the structures of and the procedures of the EU. For example, I think it's absolutely nonsensical that only the Commission has an exclusive right to initiate legislation. This should be possible, for example, for the Parliament also. Then we would get even more, you know, social policy measures. But the problem is, of course, institutions and procedures. And here we have the following problem. And with this, I close. We have still the same institutions and procedures, more or less. Some changes which were made long ago, for example, you know, in the beginning, we didn't have a European Parliament. Then we discovered the European democratic deficit. And then finally, in 1979, we got a European Parliament. By the way, in 1979, we agreed all, you know, all the actors agreed, we should have one vote, the same voting procedure all over Europe. And they said it will come soon, until next time. Now we have 2023. Next year we will have the election for the European Parliament. We still vote according to Italian procedure, to German procedure, to French procedure. We have no unified European voting procedure, you know, which is such a shame. Things take so long, you know, but the problem is the institutions are made for 6 homogeneous countries. And now we have 27. We had already 28 before the Brexit. And as I told you at the beginning, we will have around 35 soon, you know, when the Balkan countries are coming in and the Ukraine. Well, this cannot work permanently. For example, you know, the structure of the commission is that each country, even the very small countries, are represented in the European Commission. We don't need so many commissions. You know, it's absolutely nonsense. What did we do? Now we have first-grade commissioners and second-grade commissions, you know, which is a little bit ridiculous, you know. It doesn't make any sense. In short, we badly need a reform, amendment of the treaty. And of course, if you go beyond labor law, then of course you come to what about foreign policy? You know, in every measure on foreign policy, you still need unanimous voting, which is ridiculous. We never can have a European army because we need unanimous voting, you know. You never will get it, you know. You see, it has to be amended. But to say that it has to be amended is very optimistic, because for an amendment, you need unanimous voting. Each country has to agree. Also Hungary, for example. It's very, very difficult. You won't reach it, you know, and it's going even further. It's not enough to say yes in the Council of Ministry. In most countries, you need a ratification of the amendment. And we had already the situation when a country would say yes, and then you had the ratification procedure, and the ratification procedure failed. For example, in the question of slimming the commission, you know, didn't work, you know. We had an Irish referendum which said, no, then we are no longer represented. No, we don't agree. What do I mean by this? I just wanted to tell you that, yes, there is revitalization of social policy. And I'm very happy and very proud of it. We all should be proud. But there are problems, and it's very difficult to resolve these problems. And if we agree that we need an amendment of the treaty, I'm not optimistic that we get it. You know? So we have to work within the limits we have now. And I have shown you that even there, much can be done. And there I'm optimistic that this will go on, hopefully for long. Thank you very much. My pleasure.
It is always a pleasure. Sorry, it is always a pleasure to listen to you. And now, listening to this lecture, I was thinking that it might be very helpful for anyone who's teaching labor law, European labor law. And you know, the point is that you teach in a way that this lecture might be very well used as an introduction into European labor law, as in the middle to engage in the discussion, and also in the end as a material for the reflection and also for some critical insights.
You can do it as you want.
We will do it, and I think in all the ways which I've mentioned above. And also, Manfred is always very critical about using digital devices and says that PowerPoint does have neither power nor point. And I think today Manfred demonstrated to us that his speech had a lot of power, even without PowerPoint. And the point was also always very clear, and this time as well. The point is how to trace the evolution of European labor law. And I think that this lecture is one of the best way to launch our hub, our International and Comparative Labor Law Research Hub, because within this hub, we are supposed to create the database of lectures, of such prominent lectures and researchers and Manfred-wise, which would be accessible from elsewhere around the globe. And people would be able to understand what European labor law is about and have also the probably critical approach to this, thanks to you, Manfred. So we are really very thankful for the effort which you made to come and to speak today for us. Thank you very much.
My pleasure. You should tell the students if they have questions or whatever, they can reach me via email. I can handle email. I'm not very good in digital things, you know, but email I more or less can handle.
Okay. So the email of Manfred will be exposed on the page of our hub. And if any of the students would have any questions, they are very free and very welcome to write to Manfred directly. Thanks. Okay.
Okay.
Have any questions? Thank you so much.
Oh, okay. Go on and on, but I see that I already have spoken too long.
Succeeded to portray the evolution, the vector